Hi, everyone, and welcome to another edition of CCK Live. My name is Christian McTarnigan, and today I am joined by Amy Odom and Elise Phillips, and we're going to be talking about common mistakes in TDIU VA claims. So we have a lot of videos and a lot of information on our blog about common mistakes that the Veterans Administration, that VA makes, but today what we wanted to focus on are mistakes that claimants and veterans might be making when they're seeking TDIU, applying for TDIU, trying to support their entitlement to TDIU. So just a little bit of a different spin on it. But just first, really basically get into what is TDIU. So first, TDIU stands for Total Disability Based on Individual Unemployability. So that's why we call it TDIU, because that's hard to say. It's a disability benefit that allows veterans to get and be compensated at a 100% rating without being a scheduler 100% rating, which means that all of your ratings add up to 100%. So in the scheduler rating 100 can be really, really difficult to achieve. So when a veteran can't work, when you can't work, you should be compensated at that 100% level because you are unemployable. And TDIU is awarded, and I just want to use the language that VA is going to use, when you're unable to secure and follow a substantially gainful employment secure and follow substantially gainful employment as a result of your service-connected disabilities. So that's just really basic. That's the definitional part of this. So Elise, do you want to talk a little bit about qualifying for TDIU? Because there are sort of two ways, right? There's this quote unquote scheduler way, and there's an extra scheduler way.
Absolutely. So the regulation recognizes those two ways. Scheduler really just means that you qualify based on your combined evaluation. So either you have a service-connected condition rated at 60% or higher, a single condition, or you have two or more service-connected conditions where one is rated at 40% and the total combined rating is at least 70%. That's one way just to get into the TDIU realm. It doesn't mean you automatically will get TDIU, but it brings you there.
It means that the VA will adjudicate the issue right off the bat, right? As opposed to having an additional step, which was what you're going to talk about if you're an extra scheduler.
Exactly, with extra scheduler. So you're still entitled to TDIU if you are unable to perform what's called substantially gainful employment. If you do not have those combined evaluations that are either 60 or 70 for a combined total. But what you need to do under this extra scheduler realm is that your case will actually be referred to what's called the Director of Compensation Service. The director is going to look at your case, determine whether he or she agrees that your service-connected conditions prevent you from working, and then they will make a recommendation to VA. VA being either the RO or the board, whoever's adjudicating the issue. At that point, VA is either going to agree or disagree with the director. They don't have to do either. They just have to take it into account. It's kind of just that extra step when you don't have the combined evaluations. But I will say if you get a negative opinion from the director, you should definitely take your case up to the board.
So some of the mistakes that veterans can make in this situation, for example, are it's not bringing up the fact that you have a high enough rating for the VA to consider it immediately or without having to go to the director. Or maybe if you have an extra scheduler adjudication, not challenging the decision, even though the Director of Comp and Pen says that you don't qualify.
The other thing that we're going to touch upon really quickly is applying for TDIU. This is another big mistake that we see, Christian, in our practice is that people don't fill out those, what they're called 8940 forms. So 8940 forms, what we call them typically. This is a application for an increased compensation based on unemployability. You're not required to fill it out based on VA law. Technically, the issue of IU can be raised just based on the evidence in your record. However, these forms do provide VA with information they typically will need to be able to fully adjudicate your case. And it's also going to be a lot clearer that you're trying to apply for IU if you file one of these forms during the pendency of your claim.
Yeah, at least that's a really nice segue into the next part of this presentation, which is about common mistakes that people make when they're trying to get to TDIU. And the first most important mistake that we see a lot in our own work is not returning the 8940. It's not a mistake because it's required, because it's not required. VA is supposed to be able to award the highest benefit available, including TDIU, without this form. But the fact of the matter is, it rarely will without the form. And the form is really important because it contains a lot of information that VA actually needs to determine whether the veteran qualifies for TDIU, including work history, educational history, what kind of skills the veteran has, when the veteran last worked, that kind of stuff. So like we said, it's not actually a requirement because TDIU itself is not always a separate claim. If you are seeking a higher rating for example, a back disability, and the evidence that comes in while you're trying to get from like 20 to 40 for the back shows that you actually can't work because of the back pain, then that automatically triggers VA's obligation to consider whether you're entitled to TDIU, regardless of whether you submit the 8940 or not, the form. But then ultimately, what's on that 8940 is going to be helpful to the VA and potentially necessary to the VA in determining whether you actually qualify for the TDIU. So that's why it's important to always get that form in.
Yeah, absolutely. And I think we've probably all have had cases where they might say, hey, maybe TDIU is at play here, give us the 8940, and then the veteran, for whatever reason, doesn't send it back, and then that case is over. Unfortunately, the board and the VA will deny it. Yeah.
And the other thing is, even let's say the veteran has had this 40% rating for the back for 15 years, but recently had to stop working because of repeated back surgeries and it just got too bad. The veteran can submit a new claim for TDIU too. So like you can just ask for TDIU. You don't have to ask for an increased rating for the back. And also the entitlement to TDIU doesn't have to be based on solely the back. Like say you also have a service-connected mental health disability along with like a shoulder disability. VA has to consider all of those disabilities in determining whether you're entitled to TDIU, and you can start that process by just submitting the 8940.
So I'm going to hit a little bit about the types of evidence that you as a veteran who wants TDIU can be submitting, and then Elise after that is going to help you understand sort of what VA is going to compare that evidence to. She's going to talk about the TDIU standard. So one of the things we just wanted to highlight is, sometimes veterans aren't really providing the best information to VA to show that they are entitled to unemployability. This is complicated. We totally understand why, but we just sort of want to hit some of the highlights that might help you potentially set yourself up in the best position to maybe get a grant. So VA is really focused on medical evidence. But what we really want veterans to remember and claimants to remember is lay evidence or evidence that you submit, evidence that is submitted by your spouse, friends, employers. It's referred to as lay evidence. That's just because it's not medical evidence, but that can be crucial in getting showing entitlement to TDIU, talking about your limitations on work, talking about how your disability limits you in the way you can walk, lift, all things like that. Also, potentially private medical records. If you have any treatment that you're seeking outside of the VA system, make sure that you get the proper release in, make sure you get those get those records into VA, because they're supposed to consider those in addition to any VA treatment records you might have, any exams you might have. Also, employment records can be really important. Again, these are the private medical records and employment records. These aren't documents and records that VA would necessarily have. You might have to send it into VA in order for them to consider it. Social Security determinations can also be helpful, more so in my practice, because of all of the sort of documents that come with the determination, right? They talk about how you can lift, walk, your prior history, what type of experience you have. Those documents are really helpful because it can be vocational evidence, which I'll talk about next, to support your TDIU entitlement. And then, of course, like I alluded to, expert vocational reports. There are people who do this for a living. They look at what your limitations are, your past work history, what you can do now, and they make a determination as to whether you can actually work. And it can be helpful to seek opinions from these vocational experts. And the reason why we want to talk about vocational experts is because VA often relies on VA C&P or medical examinations to determine whether you're entitled to TDIU. But many of these professionals aren't qualified to actually make that determination. And there's some case law, we won't really get into the specifics of it, that outline the fact that VA examiners aren't employment experts, aren't vocational experts. Lots of times they don't have the information that the board needs to determine whether you can or can't work. And they'll say the service-connected disabilities don't render Mr. or Mrs. X unemployable. And so just be on the lookout for that, because that's technically not competent evidence to show that you can or can't work. But it is one of the things that VA tends to look at. And so it's important for you when you're working your case to point that out. So Elise, now we've been sort of talking about TDIU in the abstract. Let's get into the standards. What are the requirements?
Sure. So I mentioned this phrase before. What you need to show that you're unemployable in the VA world is that you can't complete what's called substantially gainful employment. So that's both whether you're able to obtain it or maintain it. What is substantially gainful employment? It's a multifactorial test. We have more answers from a recent case called Ray v. Wilkie, but we know that there is an economic and a non-economic component to substantially gainful employment. The technical definition is anything that's not marginal employment, which is going to lead me into what's marginal employment. VA is going to consider anything that's marginal is going to be something that the economic component, which I just mentioned, it's going to earn you less than what the federal poverty threshold is for one person. That's one way you can achieve marginal employment, or be classified as marginal employment rather. The other way is what we call protected work environment. So this is a little bit more of a non-economic component. Protected work environment is basically what we see when we see someone who is employed, but they're receiving very unique, special, significant accommodations that don't actually reduce the earning benefits of a veteran. So that means that this is a unique case that if they weren't employed in this particular situation, they otherwise would be unemployable. You might see that if you're seeing someone being excused from critical functions or things that would be critical functions of a job normally. If the person's less productive, less reliable on others at work, but he or she is not seeing any sort of consequences for that. If you're not being penalized for behavioral issues, that type of stuff. We most commonly see this with family relationships. So say a veteran's working for his brother's coffee shop or something like that. He's not really performing normal duties that would be expected of a coffee shop employee, but he's still working there because his brother's kind of employing him. That's an example of protected work environment. There's many examples of it, but that's one way that you could potentially still be working and be entitled to TDIU.
The only thing that I wanted to just one of the issues we see and why we're bringing this up is you might think, well, I'm working, so I'm not entitled to TDIU. But if you're making under the federal government's, I always forget the number because it does change a little bit every year, threshold for poverty, you can be doing that and still be entitled to TDIU, right? That would be the
Absolutely.
marginal employment element of it. And you can be, and the way that I always think about it is protected work environment, at least. I think you described it really well, but basically like you would never, like you're employed in a way that really no person who just would apply for that job would be allowed to function in, right? I see some cases take a lot of days off, take half days, leave when you get upset, don't show up when you don't want to work, but you still have that job, right? So that's sort of getting into the realm of sort of protected work environment. Just to sort of give two examples of that, you could still be entitled to TDIU even in that situation we're working.
Yeah, so basically the long and the short of it is you either have to not be working at all because of your service-connected disabilities, or you can be working, but you're not making more than the poverty threshold, or you have really super special accommodations that nobody else would get because of your service-connected disabilities. So that's really important. It has to be because of your service-connected disabilities.
So, to touch on some of the things that we would see that what the board or what VA in general would look for when they are determining that you can't perform substantially gainful employment, we get a lot of answers from Ray, and Ray also looks to Social Security, which we'll touch upon in a moment. But the board, VA, or whoever the adjudicator is, needs to look at the veteran's history, what their education, skills, and training are. So that's a vocational component. It's not just what they're able to do, literally because of their service-connected conditions. It's also what type of background they have. For example, if someone is only constrained to sedentary work, but he or she has no previous experience or doesn't have the education required for sedentary work, that would be something that they would have to consider. And then we're looking at the physical and mental abilities. That's going to be what's combined based on your service-connected conditions. So you have to look beyond what's not service-connected. Some physical considerations would be whether someone is able to lift, stand, walk, sit, those type of things. Whether they're able to do, even if someone's only able to do sedentary work, they could maybe potentially still work. And what I mean by sedentary work is there is a technical definition, but it's mostly seated work. But someone who can't sit all day still can't perform sedentary work because you need to be able to sit, right? And we see that a lot with different orthopedic conditions, different pain conditions. We see someone who can't be seated in a certain position for a while. We've seen cases where we've been able to gain entitlement for unemployability benefits because someone just who can only sit for a certain amount of hours maybe still can't do sedentary work. The mental ability is more whether someone is reliable, whether they're able to concentrate, to get along with coworkers. If someone has a really short fuse, they might not be able to achieve substantially gainful employment. We also see, issues with people who aren't reliable. They sometimes might have trouble leaving the house. That's another condition. You need to be present in your job to be able to perform substantially gainful employment.
And a lot of these factors you're talking about, Elise, are relevant to what you said, Amy, which is when someone can't work. You're not working, and the VA is going to look at these factors to see if you could, despite your service-connected disabilities, well, I'm phrasing that in the positive, if you can't, because of your service-connected disabilities, perform substantially gainful employment. So just to sort of finish that marginal protected, and then the situation where you can't work. These are the factors that VA should be looking at, and the factors you should be highlighting to VA, and the symptoms and the effects that your service-connected disabilities have to hopefully get you in your best position to maybe get a grant. And you mentioned Social Security, Elise.
Yeah, so that's the next mistake that we see a lot is people just assuming that because they're on Social Security, they get Social Security disability, that they automatically qualify for TDIU, and that is not true. You can get both. There's no prohibition against collecting both Social Security disability and TDIU based on your service-connected disabilities. But just because you get Social Security doesn't mean that you're automatically going to get TDIU. The VA is not bound by the Social Security Administration's findings as to the severity of a veteran's service-connected disabilities or the impact on employability. And we see it quite a lot that VA will deny TDIU, even though Social Security has found that those very same disabilities prevent the veteran from working. So don't just assume that you're going to get TDIU if you have Social Security. VA will have to consider those findings, but it's not bound by those findings. So you want to make sure you get additional evidence in that describes the impact of your service-connected disabilities on your ability to work. Because another thing about the Social Security finding is that it may be based on more than just your service-connected disabilities. Say you have service-connected back disability, service-connected headaches, and service-connected mental health disability, but you also have a shoulder disability that isn't related to service. And if Social Security has considered the shoulder in determining whether you're unable to work, VA will automatically, in most cases, say, well, this is of no use to us because it considers the impact of the shoulder. So that's why it's really important to make sure you're still getting that evidence in, even if you're on Social Security disability.
And another issue that sometimes we see is a veteran will get a grant of TDIU and they think they're done forever and that's it. They have TDIU, it's permanent, it's never going to go away. So we just want to stress that TDIU isn't a guaranteed benefit forever. VA can take your TDIU away for a couple of reasons. The first is if you show, and again, here's the buzzword basically, that you can sustain substantially gainful employment for a year or more. So if you have TDIU, you get a job that's considered substantially gainful, so you're making over the poverty threshold, it's not protected, things like that, then VA can take your TDIU away. Another reason, and something that we do see vets do from time to time, is not sending in your employment questionnaire. It's the form, VA loves forms, everything's on a form, here's another form. VA form 214140 is going to ask you every single year, are you working, and some information about that. So you got to send that form back, or it's something that the VA can use to take your TDIU away.
TDIU can be a very confusing area of the law, so it's always beneficial to seek representation when you can. You are, as a veteran, legally entitled to representation, whether that's from an attorney, a VSO, and they can really help you with some of the intricacies involved in TDIU. So we always suggest to seek representation if you feel like you need it.
And I would just add that you can find a lot more information on TDIU and submitting claims and everything else on our website or on our blog, cck-law.com/blog.
And thanks for joining us, everybody. And don't forget to follow us on social media to stay in the know about all veterans-related news.